Just keep it on. It's really the it's only it's just nobody's on it.
Go ahead.
That's not my client, Judge. Todd Pete, my case 2022 CF 336. We actually went to FSU Strozier Library yesterday, Judge. They're working on getting us some more documentation. We have filed a Brady demand. I think we have it set for a hearing, I believe, with your court. So I would ask that we would set this for that same day of that hearing, Judge.
What's that name again?
Peak.
That'll be 226. Be heard at the same time as the motion.
That'd be fine, Judge.
Yeah, 226.
Yes, motion hearings on 226.
The next one is James Rackley, 2024 CF 2477. We are negotiating with the prosecutor, Mr. Hughes, about a resolution. If we could have 30 days, Judge.
Mr. Fuchs, anything to add?
No, Your Honor, he's asking me to be more reasonable, and I ask for reasonable reasons to be more reasonable.
And we're working on more reasons, making more reasons. Time saving for you, Your Honor.
325 at 230.
Dominic Rondinelli, 2024 CF 2769. We're trying to get more reasonable again with Mr. Fuchs. And but I think we're working on a resolution. 325, is that the next one, Judge?
That is 325 at 230.
And the last one, Judge, I'm covering for Mr. Davis is 2024 CF 3341. State by prosecutor, Mr. Fernandez is here. I think they want to set it for April. Case manager.
Mr. Fernandez,
That's fine, Judge. We're just starting discovery right now. No objection.
415 at 230.
Thank you, Judge.
What's the name?
Rajiv Shah, SHAH, man.
Again?
415 at 230. Yeah, there's no room. There's no room. All right, Ms. Adelson. I'm going to send you a prompt to unmute on your side. Did you get the prompt? I see your lips moving, but we cannot hear you. One moment, I'll send it again. Yes, he needs to get set.
Okay.
All
Can
right.
you hear us, Your Honor?
I can hear you clearly. Let's go ahead and address Donna Adelson, 2023 CF 3226. Zellman?
Good afternoon, Your Honor. Joshua Zellman on behalf of Ms. Adelson. Jackie Fulford on behalf of Ms. Adelson.
There are a couple of things that we wanted to address initially. The state had previously perpetuated the deposition testimony of Dr. Clark, the former medical examiner. That was done by prior defense counsel. We've reviewed the material. There was one portion at the end that we had requested that they edit out, but we would stipulate that would be appropriate to present to the jury during the trial in our case. We've spoken with Ms. Adelson about that as well. And even though we were not counsel at that, defense counsel didn't ask any questions, and that would have been our strategy as well.
Very well. You may continue.
We are also stipulating to the foundation of the extraction of Wendy Adelson's cell phone that was conducted by Marsha Rodriguez, who will be out of the country at the time of the trial, so that they don't need to present her testimony in order to introduce the contents through other witnesses. We did want to inquire with Your Honor about the status of the in-camera examination of prior investigator.
With that, Lynn, has a date already been set for that?
I don't think so. Did we didn't set a date yet.
And I provided his cell phone number.
This would just be me meeting with him. It's not a
Okay,
motion.
yeah, no,
Okay.
I'll follow up on that.
We do have some issues with regard to discovery and prior case management. Your Honor had indicated that based on the conflict that existed in prior counsel, you would understand if we were going to redepose some of the witnesses that had previously been deposed by prior counsel. There are three such.
Hold on. I believe I said if you needed to raise the issue, you certainly could, but
We'd like to
do
raise the
not
issue.
accept that as a blank permission to redepose.
We didn't, Judge. We didn't.
Okay, go ahead.
So we've been working to schedule depositions with the state, and for this morning, for the first time, we learned that they do object to us redeposing 3 of the state's witnesses. One would be Chris Corbett, the second would be Special Agent Patrick Sanford, and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition would not be lengthy, but we do need to redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands. And to the extent you'd like to know further why we would like to depose these witnesses and that particular conflict, we'd like to be heard ex parte and in camera with Ms. Adelson present to provide some information to the court as well on some attorney-client privilege information.
All right, this is going to need to be memorialized to the extent that you can in a motion. As far as any hearing that would occur in camera, I will make a decision on that. But first, I actually need to read the basis of what you're seeking and why.
Now,
Thank you, Judge.
with respect to Chris Corbett, Your Honor, we haven't even received Sergeant Corbett's completed revised presentation. That is what the defense intends to take his deposition concerning. We've been told that we will have that presentation by this discovery cutoff, and so we were actually going to have to file a motion to extend the discovery cutoff for purposes of taking his deposition. And that was tentatively scheduled for May 14th. Being that that would give us approximately 2 weeks to review the revised presentation. That's the reason for Mr. Corbett's. That's not a conflict issue, but we can certainly memorialize that in a written motion if that's what Your Honor would prefer.
Just going back and looking at the dates and the different cutoffs. 4:30 is the discovery cutoff by order right now. Ms. Dugan, as to providing Sergeant Corbett's presentation, why is this going to be so lengthy?
He's just working on the cases that are in front of him right now, but he has assured me that he's going to be working on this presentation as soon as he possibly can. I don't know of any new information in the presentation than what's already been given to him. It's more of formatting and making it look better as opposed to anything substantive. And my memory, if it serves me correctly, is that prior defense counsel's deposition of him was done after the same, as far as them getting the copy of what we were gonna use as far as everything substantive we were possibly gonna use is in there. But, you know, the final result might look better at trial and be formatted in a different way. But substantively, it was all there. We certainly, and we want to be reasonable. We do object to, as far as all of these witnesses, they sent us about 24 hours they need to depose several witnesses. We worked with them to get times that we are available and will continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants. Looking at the rule 3.220, it says any cases, including ones with multiple co-defendants or even consolidated cases, no one should be deposed more than one time unless good cause is shown. If it's something that pertains to their client that's, new, we don't have any objection to that. But as far as just setting these people for hours and asking them a lot of the same information that's already been said in prior depots, we would object to ask and answer and not want those people to have to be deposed again. And then as far as the folks that they named, I think it was Agent Stanford and Corbett and Rob Adelson, that Donna Adelson's former counsel has deposed. As the court said, we would ask that good cause be shown. We're fine with that being ex parte and in camera. But we would ask to have that done, be able to weigh in on that from our side as well in those same situations, and object to them being deposed again. If there is some new information in Corbett's presentation as of April 30th that they didn't know about before, we would absolutely be fine with him being deposed on that information, but just not having to go back through what's already been said with, hours and hours of depots and prior testimony.
All right. What I am not fine with is moving this trial date if it does not need to take place. April 30th is the discovery cutoff. We're going to leave that in place for now. Everyone is to work accordingly up to the deadline. If it has to be extended, it will, but there's still 2.5 months to that point, right?
Yes, sir.
We'll drop the motion, Judge.
Yes, sir. And, certainly, by way of a brief response, and I will be brief, the rule cited by the state contemplates that the co-defendants are all being tried at the same time or have all been arrested. It defies logic to believe that
These trials have been spaced out. They are not co-defendants that are linked by one information.
Thank you very much, Your Honor. Lastly, this morning, I provided a proposed order to the court from the August 30th and September 6th motions in limine. I prepared those based on the transcripts that I have prepared of those hearings. I provided them to the state twice over the last month and had not gotten a final answer. Does Your Honor want me to submit the transcripts from those hearings?
You can do so. I'll review them. Ms. Dugan, as the proposed order, is the state objecting to it, or you don't have an opportunity to review it?
I did speak with Ms. Kaplan about that and we reviewed it. We don't have any objection.
Very well. I'll still review the transcripts to ensure it is accurate, but trust but verify. Go ahead.
Yes, sir. There are some additional motions to suppress and a handful of motions in limine. I'm hoping to get the motions to suppress filed in the next week to 10 days so that those can be heard properly. The motions in limine, we're certainly going to try and get those filed early to mid-April so we can get those heard as well. I just wanted to let the court know that the motion to suppress that we filed last week is not the only one that's coming.
I believe the date that we were going to have for the pretrial motions that was going to take place on Friday, May 16th. Obviously, more that can be heard prior to then will lessen the burden on that day, but anything that's still outstanding, that's the day it's going to be heard before we move into trial posture.
Yes, sir. Certainly with the scope and breadth of the motions that we are working on, we'll try and get those on your calendar much sooner. And lastly, I wanted to update the court on the expert that has been retained. I spoke with them for the motion for change of venue. I spoke with them yesterday, Mr. Fulford and I did, and they are intending to provide us with the end product by the end of the first week of March. And as soon as we have that, we'll be providing that to the state and get that set, provide that to the court as well and get it set for here.
All right. Concerning this report, and I'll leave this to your judgment, but do any of these matters need to be filed under seal to alleviate essentially the issue you're complaining of for the motion?
Yes, Your Honor.
Very well. Ms. Dugan, does the state have anything to raise today?
No, sir.
Right. Upcoming through the deadlines, as we've spoken about before, the discovery deadline will be April 30th. We'll also have one last case management on March 25th at 2:30. As needed from there, we'll have different hearings with motions and we'll continue to move to June 3rd.
Thank you, Judge.
Thank you, Your Honor.
We are in recess. Let's move on with calling the other matters this afternoon. Jail, that concludes the appearance for Mrs. Adelson. She's finished. Have a good afternoon.
Thank you, you too.
Mr. Zellman, go ahead.
I've just received from Brett Brown. He covered for me on my 2 o'clock hearing. It's State of Florida versus Booker Flowers, 22 CF 497. He's going to accept the offer that has been made. He says Mr. Brown has to get him transported from DOC. He's requesting a plea date in April.
Right. For Mr. Flowers. We on 4/15 at 9 o'clock. Mr. Brown will need to provide a transport order.
I'll get that message to him right now. Thank you very much, Robert.
Good afternoon.
Bodman, good afternoon. You have Angela Harrison.
Yes, Your Honor.
You can go ahead and proceed.
Your Honor, I do have Angela Harrison. The only thing that I think I'm waiting for is body camera footage. I did file a motion basically to dismiss, seeing that I have not received the body camera footage for months despite requesting it. I reached out to the public defender's office. They have not received it. I did get a link from the state attorney's office, and that I did download that link. The only thing that was provided to me, I believe it's police reports, which I already have. What I'm basically looking for is the recorded interviews of my client and the alleged victim in this case, which is.
Yes, Your Honor, according to our record, discovery was right up, I think my secretary said back in August. The link that was sent to him was from the Lancaster Sheriff's Department in the recent, make sure I got right over camera. I have not gone back to review and see what's actually in it. I just immediately forwarded it to him. I will go back and review and see what it is, with more detail. But as I understand it, it's all been provided and previously provided, and it was provided to the attorney before that.
Right, Mr. Todman, I'm not sure what the issue is of getting a hold of these videos, but it does sound like they do exist.
Yeah, I get that, and that's why I mentioned back in December. This issue was actually before I filed my motion. It was presented, at a case management. The last time I think I was here was December, and I indicated I need to continue because of the videos, and still haven't seen these videos. And then I, after the correspondence with Mr. Felix, I reached back to former counsel, inquired whether or not they received the videos, and they informed me they did not. So from the motion I filed, Your Honor, you could see that in December, what was represented to me is that the government needs to reach out to LCSO for them to provide a video. Again, we're now in February, and all I'm asking for is that, you know, in the probable cause affidavit, the officer alleges that he uses body camera video. I understand that he also interviewed the alleged victim as well as my client. If those interviews are reduced to a recording, I should be entitled to view that, you know, that now, that being the case, I think they filed an information back in August of this year. And I was trying to review that evidence to move the case along.
I have gone back and looked at the Axon link that I just clicked on, which is the one that was provided to Mr. Todman, and